Hi, I'm Larry Mike Renda, and welcome to this edition of Excelsior Forum. A lot of people say you can't fight City Hall, but we have somebody here that says you might be able to. A renowned attorney, Mr. Rob Agostisi. Rob, so glad you could take time out of your busy day and
Larry, thank
come
you
down
so much for having me. I'm honored. Thank you.
and answer some of the questions that some of the people have. And one of the things that people don't understand, and everybody's not lawyers. I mean, you have a renowned background. You went to school. Where did you went to college?
I went to college upstate in SUNY Albany. I graduated there in '98. I went straight to law school at Hofstra University School of Law and graduated there in 2001. I've been practicing attorney ever since.
I know you have a lot of profound experience, especially in the courtroom. Municipal law. Let's talk about that. A lot of people don't know, is regular law, municipal law, is it the same thing?
Municipal law is a branch of law. It's the branch that affects all localities in New York State. And it is a vast area of law. It's expansive, and it touches upon people's lives in ways that they might not otherwise know of or anticipate until you find yourself in a dispute with a municipality or a locality, and then you start to figure it out rather quickly.
Now, when we talk about municipalities, these are villages, towns, counties, everything that's pretty much not federal, or exclude just state and federal?
For the most part, that's a pretty good working definition. It's everything that's not federal, but basically you're talking about counties, towns, villages, and cities. Those are the different layers that exist under the municipal home rule in New York State.
Now, a lot of people too, we hear about town codes and bylaws. Are these the same as regular laws?
Well, bylaws are a set of statutes, basically, that are adopted by a municipality, and they govern a transaction or a series of transactions that applies to the population that it governs. It's kind of like the bylaws in a corporation, for example, but you'd call it a code of ordinance here, and it's subject to the overarching charter of that municipality, which is just like a constitution. It's the same concept. And under that, you have also a garden variety resolution, which are the most frequent laws that are passed by municipalities. And sometimes you even have something called local laws, which are like charters in the sense that they have the force and effect of state law. So it's charter on top, then your code of ordinances, and then your resolutions. But off to the side are local laws, which affect a very narrow band of transaction. And sometimes the state requires that you pass those types of laws because of notice provisions and because of the subject matter that's being governed as well.
Now, the state empowers these towns and these counties to make certain rules and regulations. And these municipal laws, these so-called codes, they're probably closer to our ways of life down here as far as, let's say, regulations, stop signs, zoning, planning, stuff like that.
Yeah, absolutely.
Now, occasionally, probably say more than occasion, people break these codes, or they didn't understand them, or a lot of problems with buildings and stuff like that. That is probably, I would say, one of the centers of municipal law, or there are a lot more branches up from that.
There are a lot of branches. It goes beyond just that, but that tends to be the area where people get roped into it the most quickly because, it tends to be a function of zoning and land use in particular. That's where you really start to develop a lot of familiarity with your local government. When you go to apply for a building permit, for example, or a variance from the Zoning Board of Appeals in your municipality, you really start to see the wheels of government in action. And that's where most residents gain their first exposure. But that, for example, and we're talking about land use now and zoning, that would fall under the rubric of a code of ordinances, for example.
So the code of ordinances, they're still laws, right?
They are absolutely laws, and they have the full force and effect of laws. And in municipalities, again, the only thing that exceeds that in a municipality is its actual charter, that which has the force and effect of state law, along with local laws. But there's also a doctrine in law known as legislative equivalency that people are not necessarily aware of, but that's what sets sort of the ground rules about the primacy of laws: charter, code of ordinances, resolutions. And what that law stands for is the principle that it takes a law of equal or greater import to change another law. So you can't, in other words, you can't use the Code of Ordinances to change a provision in your charter. Right? It would work the other way around. You'd use the charter to perhaps effectuate a change in the code. But that's something called legislative equivalency, and that is something that people eventually start to learn about, even if they don't know it by name at some point or other. The hard way, exactly.
Now, with the town codes that exist, now, stop me if I'm wrong about this, but no town or village can make a law or a code that supersedes state or federal law, right?
That's a great question, and that cuts right to the heart of the municipal home rule, as it's called. And it's a little bit confusing. It's not immediately apparent to people how this works, or lawyers for that matter. It's a confusing topic because the way it generally works is that the laws that are adopted in a locality or a municipality are generally not supposed to conflict with state law. But there are exceptions to that. When you're talking about the state constitution, nothing a locality does may conflict with the state constitution. When you're talking about statutes that are adopted by the New York State legislature, it depends on the type of statute that the legislature is adopting. And there are two general types. One's called a general law, and one's called a special law. A general law affects all bands of localities, counties, cities, villages, and what have you. And in that case, that supersedes all local law, when we're talking about general laws, that is. When you're talking about special laws that deal with only an isolated municipality or two or three, it doesn't necessarily have reign supreme in that instance. So it depends on the type of law we're talking about, special or general.
Now, also applying to federal law, wouldn't it be the same thing? No town could create something that, say, went against a federal law or something that might be deemed unconstitutional.
Generally speaking, that is correct. There's a lot of gray area in there. There's a lot of wiggle room. There's also the supremacy clause that prevents states from passing laws that interfere or frustrate federal purposes as well. But the interplay is what's called federalism. And it's an entire branch of law that you could spend an entire career trying to learn about and probably not succeed.
God. But with all these local problems that we have, now, if somebody wanted to challenge, let's say there was a town code or a town law that was just recently enacted, and they feel that as if it was targeting them, it was meant almost like discriminatory towards them, mm-hmm. What would they be able to do?
Well, the standard format for a challenge is something called an Article 78 proceeding, and that exists under Article 78 of the New York Civil Practice Laws and Rules, which is like the procedural handbook that lawyers use in New York State. And what that allows a citizen to do is challenge an action of the government when they want to argue, more or less, that the government is exercising their authority in an illegal manner or an unlawful manner. Right. Or the government's not doing something that it's supposed to be doing. So there are different types of what are called common law writs that are incorporated in an Article 78 action as well. Basically, the thing you need to know more than anything else about an Article 78 is this. Government actions are generally presumed to be valid unless they are arbitrary and capricious, and that's the standard for overturning a government law, regulation, rule. Arbitrary and capricious. It's a very, very high threshold for a citizen to meet. Basically, it means that the government action has to be wholly irrational. Now, in many examples, a law that applies to just several people or one person might fall into that category, but it depends on what's being regulated. It's more likely that you'll have a viable challenge if you are being singled out or cherry-picked by the government, but not necessarily. Article 78 is considered to be the safeguard of what's known as procedural due process under the United States Constitution. That is where citizens can pursue any claim deprivation of their procedural due process rights in Article 78 proceeding. That's where they're supposed to do it. However, they can also go to federal court potentially and claim various forms of maybe discriminatory conduct, selective code enforcement, challenges that exist for retaliation and whatnot under the First Amendment, under the Equal Protection Clause, under the Due Process Clause itself, because there's another form of due process known as substantive due process. And there are a multitude of challenges that exist because there's a portal statute that allows citizens to sue municipalities directly. It's called 42 USC 1983. And those challenges, when you want to say that when you want to claim that one of your rights was abridged under amendment, you sue pursuant to 42 U.S. 1983 in federal court. That is another option, separate and aside from an Article 78.
Now, also, when it has to do with the police and law enforcement, some of these towns that we have here on the island have their own police department. Now, their codes that they create, are they the same, or are they guided by a different law, maybe with the state or the Fed?
The police and law enforcement are governed by a panoply of laws, really. It's not just one law that applies to them, it's many. And it depends on the police department and what type of case that you're involved with the police. For example, there are, and I've tried these cases several times in my career, there are false arrest and excessive force cases. And typically what you see is those are plaintiffs bringing those cases in federal court to enforce their federal rights, typically to due process, to equal protection, and especially under the Fifth Amendment for unreasonable search and seizure. You see that a lot. But that's only one type of case that's brought with respect to police.
Right.
There are many other sets of rules that citizens could have a viable challenge.
And also, there's been cases of discriminatory practice in some police departments, or some people getting raised and you didn't get a raise, and it just goes into all these things. But now, if you're being singled out, let's say the town created a code that applied just to builders, that all builders had to have a certain truck or something like that. Could these builders get together and challenge it?
Potentially, but it depends on what the regulation states. If this was if was a veiled manner of discriminating against those builders because they disapprove, say, of their political beliefs or affiliations, yes, that would present a colorable claim. However, if there's a bona fide safety concern that underlies those regulations, it might not work out, and it might not be tenable, and it might not be worth the builder's time or resources to sue. It all depends on the language of the statute.
Now, we have legislators, council people, stuff like that. Now, what we've been seeing a lot lately, before and during, after this election, is people coming out and stating that the member on the council or the legislator had a conflict of interest, and they want to pursue it through lawsuit or something. Is that through municipal law, or would that go federal too?
The most common form of challenge would be through the Article 78 vehicle that we were just discussing a few moments ago to address a conflict of interest. But the key is whoever's challenging it has to have legal standing to challenge it. And what that means is the challenger has to have been injured in fact. They have to have sustained some type of injury that's not attenuated, that's direct to them, in order to sustain a challenge. And that's where people get hung up a lot of times, is that they weren't individually impacted by the government decision at issue.
Right, and those damages can be financial, they can be physical, they can be mental, those type of damages you talk about. I think, what do you call them, punitive damages?
It depends on the case. In the case, we're talking about a conflict of interest. In an Article 78, a lot of those types of damages are not available. You're basically trying to overturn a government action or to force the government to do something that it's required to do legally. That's what an Article 78 is.
Right.
It's about the movement or the stoppage of that movement. That's what's primarily alleged and sought in an Article 78 action. What you're referring to is the typical slate of damages that's available in a lawsuit, say, alleging discrimination or retaliation. And yes, there are many forms of damages, like economic, which would include compensatory damages, which a lot of time would perhaps, let's say in an employment dispute, might include back pay. It might include front pay, among other forms of damages. And there's also non-economic damages, which would consist of damages for mental anguish and emotional pain and suffering. That may be available as well. You mentioned punitive damages. Those are reserved for special types of cases and conduct, where it's designed to send a message to the government. Sometimes you do see juries award punitive damages in cases like these, but just as oftentimes you'll see the judge knock those awards down substantially from what the jury may have awarded. And it's not to say the jury automatically awards punitive damages, even if they find guilt. Many times they won't.
The thing is, too, with the way punitive damages, it's basically something that's awarded by the court. And it's basically the jury or the judge turning around and saying, don't do this again, right? But if it's a $2 fine, what type of weight does that hold? You know, if it's something really bad, you want to hit him with $100,000 or something, right?
Right, and it's interesting because you mentioned a $2 fine. Another form of damages that we didn't even broach that's designed to provide a disincentive to government to conduct itself unlawfully is attorney's fees. Many times, especially in federal court, not necessarily as much in state court, but in federal court, you'll have fee shifting, where if a plaintiff wins a case, they could potentially get all of their attorney's fees paid. And that's typically, by the time a trial rolls around, hundreds and hundreds of thousands of dollars. And all a plaintiff really needs is a verdict for $1 to entitle his or her lawyer to attorney's fees. It's an interesting little twist there. Yeah, all you need is a buck, and you might be able to get yourself attorney's fees.
And that's how it gets the ball rolling, I guess, right?
Yeah, and again, it's designed to provide a disincentive to deter unlawful conduct by government actors.
Now, getting back to the localities in town, so if you were going after a town for not doing its job, let's say in the town charter it says, we're going to make sure that we pick up leaves all the time, just as an example, and they don't pick up the leaves, do you have a recourse?
It's hard to say in the abstract. But if the town has a duty under the code to pick up the leaves and it's failed to do so, that might be the subject of a viable Article 78 proceeding in Supreme Court. And it really depends on the granular language of that statute. That's what you're trying to figure out. And you could potentially compel a municipality to act in those situations.
Right, because sometimes like lay people or you'll read a law and you're not really getting the meat of the law, the interpretation of it, which is really like the meat and potatoes of it. Like, it could be a clause in there, we will pick up leaves only when the moon is full and it's a blue
right.
moon or something like that. There could be something hidden in the wordage. And I know that you have, in your past, lawyers, when they take a case, do a thing called discovery. And you are quite thorough about that.
Absolutely. And some of that stuff is borne out in the discovery process, but a lot of it is something that could be determined by a lawyer right off the bat also, maybe based on the plain language of the statute, for example. But I don't have to explain it to you, Larry. The devil is always going to be in the details with these things, and it's very important to consult legal counsel before, especially when you're dealing with complicated matters like statutory interpretation, because even in cases where that statute seems crystal clear to a layperson, it can mean something totally different to a lawyer.
Right.
And to that lawyer who goes in and then inspects the case law, that the way the judges have interpreted that statute, it may mean something else completely that goes outside the bounds of what your typical attorney would interpret that statute or how they would interpret it to read. So it always comes with a caveat. Every single law you read is get your lawyer involved early and have your lawyer research the cases to see how they've been interpreted, because ultimately that's what matters. It's what the judge says, ultimately.
And when you have a seasoned attorney like yourself in municipal law and stuff like that, a lot of these times you'll get similar cases of ones that you've already tried before or know the outcome of. So that's something that experience, bringing that in from, let's say, an attorney who does matrimonial and all of a sudden he's trying to get involved in municipality law. Each one, like medicine, law has its own specialty branches. There's some that do just will, some that do just matrimonial, divorce, stuff like that. Ones who do municipal law like yours, ones that do strictly equal rights. It's kind of like to each his own on this. But now with these town laws that come up, if the town is working on getting a law done and you want to protest, you want to stop it before it becomes a law, do you have to wait before it becomes a law, or can you actually go after it?
That's a great question, and it comes up all the time. all the time in life, you'll see this issue come up when people are seeking something called a preliminary injunction or a temporary restraining order, which can come before the preliminary injunction. But basically, that operates to prevent a certain law, rule, or regulation or an action from taking effect pending the litigation. So the way it works in practice is, oftentimes, so the government's about to do something that somebody doesn't want them to do, and they try, and the challenger will try to restrain the government from doing that by filing for something called a temporary restraining order. That temporary restraining order, if granted, would allow the parties to argue what's called a preliminary injunction. If the preliminary injunction is then granted, that would last throughout the pendency of litigation. So the government could be restrained equitably from taking part in the action that it's attempting to.
And pursuing that code or law or anything like that.
Right. It depends on whether, typically in this analysis, depends on whether the harm is considered imminent. That is a major factor, and an important one. It's a high threshold to meet also.
Right. Now, one of the cases that happens to be going on right now in some of the other parts is a lot of the municipalities, because to save money and with employees and everything like that, they're using drone systems, okay, where they're actually sending the drones out to catch violators. Either illegal dumping is one, ATV use is another, all these other things. Now, your right to privacy is a federal, right?
Yep.
But now that this drone, let's say, comes by your yard or is watching you work on your car or something like that, do you have a case with that?
You know, this is an emerging area of law because, you know, just like questions involving AI, the answers aren't clear-cut right now. And what you could see in plain view might be something that ultimately is not available under the subheading of privacy rights. But do you have a reasonable expectation of privacy in your own backyard? Arguably so. What you're seeing are happens all the time with emerging technologies.
Right.
You're seeing judges struggle with the issue, and eventually, what that leads to are appellate division decisions. Right, it moves up through the legal channels, and perhaps even decision that comes down from Albany, from the Court of Appeals, which is the highest court in New York State. And I have a feeling questions about drones are eventually going to wind up there.
Yeah, because years ago there was the argument was that if you were in your vehicle parked with the windows up, it was considered private. But if you're on a public land, like if you're in your driveway, it's one thing. But if you're on a public road, it's not considered privacy. And there was this whole big thing going on for years about
Yes.
that.
And a lot of those laws have migrated their way over from law surrounding searches and seizures by police under the Fourth and Fifth Amendments of the Constitution. I think what you're referring to is actually something called the plain view doctrine. And yeah, if you're sitting in a park, you may not have that privacy right. If you're sitting in your driveway, perhaps there's a balancing test that goes in there, and the court's trying to strike a balance. And if you're sitting in your house and a drone's looking through your window, then we're talking about something else altogether.
Yeah, because it's the interpretation of the law.
Mm-hmm.
And you know, your field of expertise, being in municipal law, is dealing with all these ins and outs. Like you said, there can be quite a many, because the way one town may write its code compared to another town may be totally different, even though there's similarities in the code.
Absolutely.
So to challenge stuff, somebody is having a problem with their town or their county, and they believe it's illegal. What's the first step they should do?
The first step is always to contact a lawyer to figure out if it's worth your time and investment. And you should contact several lawyers. That's the ideal initial solution anyway, to figure out what your rights and remedies are. And people don't understand that. You know, but if you were going to shop for cars, would you just go to one dealership? No, you should go to as many as you possibly can, knowing that there's probably a subset of cars out there that fits your particular needs. It works the same with lawyers, doctors, and what have you. Go find the person that ultimately works best for you, and who you are going to trust to take you through. Yeah,
right?
In that particular field of law,
Right.
to take you from out of the starting gate over the finish line. That's what you need. And that's where it always starts.
You can have a choice: have a Cadillac like yourself, or beat a Volkswagen.
Well, that's how I like to think of it.
Exactly. Another thing about municipal laws is employee discrimination. A lot of times, you hear these cases in the county, the towns, or villages, or cities, that one employee got something more than another employee that they think they were entitled to. Does that go under your purvey of law also?
It does. And that's you're talking about several different areas of law now, also that all fall under the subheading of labor and employment law. There's general private sector labor and employment law, which involves labor on the labor side. It's union law. That's what it is.
Right.
And on the employment side, it's typically employment discrimination matters, retaliation, and wage and hour. Those are the primary private areas of labor and employment law. But it also spills over into the public sector also, where you're now talking about a much larger range of rules and regulations. In the public sector, you have to deal with something called the Taylor Law, which is where all union law stems from and what it's governed under. And that all of those disputes take place at the Public Employment Relations Board, or PERB,
right.
Or a number of them. Some of them are also resolved through a grievance mechanism in a collective bargaining agreement between a union and a municipality. And that's just one thing. There's also civil service law, which is a whole nother area.
But the thing is, too, also just to let people know out there who are watching the show, that it's not necessarily you need to belong to a union to bring one of these actions. You could be working at McDonald's with no union, or something like they had with Amazon or something like that, right?
Oftentimes that's the case. Again, it depends on the language of the collective bargaining agreement, so you have to be very familiar with that, and you have to work with your union officials also to make sure, and be your own advocate to make sure that they are advocating, for your rights and pressing your rights as aggressively as possible. Because there are some times where the union does not have to actively pursue your rights, and in that case, what might be in your best interest is to go speak to a private attorney who might be able to step in and help. And there are plenty of instances where that is exactly the case.
Well, Rob, we're basically out of time. I did want to thank you for coming on and answering
Thank you,
a lot
Larry.
of our questions that we had.
Absolutely.
And we hope everybody has a great holiday, and we'll see you back here next year, right here on Excelsior Forum. Take care.